that's, we just recycled the
We
same
are
stuff.
live.
All right, we're back in Senate Judiciary on February 12th. We have the Defender General with us. We're shifting gears back to S193, and floor is yours.
Thank you. I'm Matt Valerio, Defender General. Had a chance to take a look at S193. Let me say, as a predicate to specific comments on the bill, that my office has always supported the creation of a forensic hospital for treatment of individuals who are involved in the criminal justice system. We had one for forever, and it basically got washed away with the, I think it was Irene, and we haven't effectively had one since. And that causes a huge hole for a group of people who get involved in the criminal justice system, who are either insane and not responsible criminally, or they're incompetent and cannot participate in their own defense. And the concern since that time has always been that whatever facility ends up being created, it has to be done constitutionally. That is, that it has to be constitutional. It has to focus on treatment, both physical and mental, and rehabilitation of individuals with mental illness or traumatic brain injury, or other brain injuries or brain diseases or defects that would basically put them there. And here is the fundamental one line to remember whenever you are dealing with this stuff. To be constitutional, it cannot be operated in a manner that is akin to incarceration. It is not about punishment. It is all about treatment. Once you get into the realm of somebody is mentally ill, they are ill. And whether they're insane or whether they are have an illness or mental defect that makes them incompetent to stand trial, the focus must be on treatment, not incarceration. And where we create systems that we call that, you can call it whatever you want. If it looks like a duck, walks like a duck, quacks like a duck, it's a duck. And if it looks like a jail, acts like a jail, and the like, it's a jail. And you can call it a forensic treatment facility if you want, but it's not going to get you out of a problem constitutionally. And honestly, it was the issue that effectively brought down Woodside, where it was sold as a treatment facility, and then everybody feds looked at it. My office, multiple lawsuits, millions of dollars of tort liability later, and ultimately it had to go away because it was a jail. It wasn't a treatment facility.
Senator Lipsky has a question.
Oh, okay.
Yeah,
I didn't know if she was just sitting there with her hand.
I appreciate that. Is there, so as this is my understanding being proposed, it would be housed within a DOC facility. That would, in my view, look like a jail, act like a jail. Do you see any way that it can be housed in a prison and be constitutional?
In a prison, I don't know. It was one of the, as I went through the bill, it was one of the things is, why is the Commissioner of Corrections in charge of this? Why is it within a jail? It is one of the indicators, at least, that this is not, as proposed, a treatment facility, a hospital. In fact, it is either a jail or akin to a jail. And it raises huge, big red flags for me. And by the way, while honestly, it's kind of the unfortunate thing is I know too much about this particular subject, but I did also, out of an abundance of caution, pass this by our appellate division to see if there was anything kind of new on the horizon. Really there isn't. In fact, what you've seen is a refining of definitions and of timeframes and of procedures that are acceptable and some that aren't. So
Quick question. The basis for what you're saying here, that it can't be operated in a manner that's akin to incarceration, where does that come from?
There's a whole line of case law on it. It's all over the country.
One place I can start.
Well, yeah, I mean, Jackson versus Virginia is one of the main areas that talks about the procedural and substantive 14th Amendment due process rights that are afforded to people who are mentally ill or incompetent and held in a forensic facility. I mean, one of the things, and I was coming up on it, because this bill is replete with these problems as it exists. And I know why, because the focus of the bill is on public safety, not treatment. Jails are really good at public safety. They're not really good at treatment. But when people's concern is public safety and not treatment, you end up with a forensic facility that is a jail. And those all around the country have been subject to attack and various receiverships and all kinds of things by federal courts. I'll just go through this a little bit. On sub C on page 2, for example, that particular section violates Jackson versus Virginia, which says that under the 14th Amendment, you can only hold someone who is incompetent based on what they refer to as traditional civil commitment proceedings for a duration that bears a reasonable relation to a reasonable time for the person to be restored to competence or determined that there is no substantial probability that they will attain competence. It does not allow indefinite detention, as this proposed statute seems to suggest. This kind of issue arises multiple times. Same thing happens in sub D, where it says that they can't be discharged for refusing to receive restoration services. Everything has to be related to a treatment modality, not kind of arbitrary time frames or arbitrary things that are not related to treatment. These are factors that are related to public safety, which I understand. Now, I want to say too that at this point, if somebody's declared incompetent or insane, the Defender General's office at that point is out of the case. Legal aid comes in and is litigating hospitalization orders, non-hospitalization orders, conditions under each one. They're the ones who do the reviews. We don't do that stuff. So I just happen to have a fair amount of experience dealing with this stuff. And so I have no problem coming in here and talking to you about it. This issue raises itself again in sub E on the next page. And what I'm trying to get this to line up so that I'm doing this right. Start over, I guess. It says competency restoration services shall be maintained until the person receives a verdict in the person's underlying case. that on its face is not constitutional. You cannot basically treat somebody, I mean, maybe this is written poorly, but you cannot treat somebody indefinitely to try to restore them to competence, because there's some people who can't be restored to competence. And I want to get back to my notes. I have them side by side on this page, but they don't seem to line up when I talk about them.
Matt, there was a suggestion.
Basically, what I want to give you an overview just of the case law.
Yeah.
But it says, this says, the bottom line is you can't indefinitely do that. And the cases around the country say you probably can't do it for more than a few months. Like the longest we've seen is 6 months. Usually, and there's a line of cases out of the like Ninth Circuit that is limited to like 4 months. This issue raises itself again and again and again in this bill. And, you know, I don't know who is, you know, I'm guessing it'll be legal aid or the ACLU or somebody who is, you know, is going to be filing lawsuits under this if it was passed as written. But, you know, as it stands, it's a bit of a problem.
Did you have a chance to see any of the recommendations from the Agency of Human Services?
Those were not provided to me.
No. There was one regarding whether or not if competency cannot be restored and having a hearing held within 40 days. I'm just rereading this here, but same idea that the person will be committed to the facility unless they establish by clear and convincing evidence that they won't pose a risk of bodily injury.
Yeah.
And if that finding is made, then the person could be released under a prescribed regimen of care. And there's a few other conditions in which the person could be released. And I can send you the document, but.
Yeah, I mean, that was another issue appellate pointed out, which was one I had already seen, but shifting the burden of proof to the person who's being held to prove that they aren't a danger, as opposed to the entity, which is the state, who seeks to hospitalize or incarcerate them, having the burden of proof that they are actually dangerous. The appellate division advised me, and it was an issue I had seen as well, that the burden of proof is always on the state to prove that somebody is a danger if they seek to hold them.
I think that was a question that I had initially too. My understanding at the moment is that it would be in some ways similar to holding without bail, and they're initially held, and then after the state meets that burden, but then the person who's being held has the opportunity to contest that and show that they actually wouldn't be a danger.
Well, you can always produce evidence to the contrary, you know, to rebut the state's case, but the state would still have the burden of proving that you are a danger, as opposed to you having the burden. And if you notice, there's also a little nuance here where the way this bill is written, it puts a burden by clear and convincing evidence on the person being held to prove by clear and convincing evidence that they are not a danger. So you got to prove a negative. And then if the state seeks to re-hospitalize the person, the burden goes back to the state, but it's only a preponderance of the evidence. So it puts a higher burden of proof on the person seeking to be released than it does on the state seeking to hold them. That's later on in the bill. But both of those things are an issue. You can choose whatever burden of proof you want to, but I think that my understanding is that to hold somebody, whether it's in a facility like this, you have to have at least clear and convincing evidence to do it. You can't do it by a preponderance.
Just, I don't know why I can't keep these straight in my head, but it's preponderance, clear and convincing beyond reasonable doubt. That's the sort of levels of proof, right? Okay,
Right.
thanks.
There are other nuances to that not worth going into, but that is of what we're talking about.
Okay, yeah, I'm happy to talk about the nuances offline.
The dismissal provisions on page 3 and 4, we also identified as being unconstitutional because you can't base a decision on whether a case has been inactive for an arbitrary period of time. Once somebody is incompetent, they have the right to these reviews. It can't be just, you can't decide basically how to treat somebody based on the length of punishment that would be available if the offense that they are not competent to stand trial for is over a certain amount or not. Once you're in the realm of mental illness, now we treat you like somebody who has been involuntarily committed. We don't base like whether you can be held on whether you have a life in prison case or a 2-year misdemeanor. Like as written, this looks like a mechanism for punishment because you can't really. How do you describe a system where the length of time you can be held when incompetent is based on the maximum sentence and not your mental illness? It just provides more evidence of what is, kind of what the intent is here.
I don't know if I'm looking at, are you looking at section 2?
I am looking at page 3 and 4. There's a lot in
section 2 is what you're looking at, or sections 3 and 4.
Page 3 and 4,
Okay.
and it is section 2 and 3.
So at least for section 2, I'm not sure I understand.
For what?
If it's a misdemeanor offense and the person has been found incompetent and they're not being held and the case is just pending in the ether for months, if not years, why would it be unconstitutional to dismiss that case?
I'm trying to find where you are.
It's line 18 on page 3.
The bottom line is it's never unconstitutional to dismiss a case. However, I think what is implied is that you're going to have people who are incompetent, who have been held for a really long time, being incompetent, and then after that, the decision about whether to dismiss or not is based upon the sentence of the offense, not the health or treatment of the individual.
So, I mean,
The criteria is wrong, and the time frames are wrong. So basically, you could have a misdemeanor where somebody's incompetent and they're being held, but if they're held for 2 years, then you can dismiss the case. Or if you have a more serious felony, aggravated assault, let's not just do murders and sex cases. 15-year felony, somebody doesn't regain competence. Under this, you could hold them for 15 years before you get to the point of having the case dismissed.
So I don't think the bill contemplates holding anybody for misdemeanor offenses, if they're not competent? Or are you suggesting if they're being held for other reasons?
Could be any of the reasons. But the bottom line is, you can't have an incompetent person and base their release on the maximum sentence of the offense. It has to be based on a medical reason, not the length of the offense. You see how that part is wrong. That part, that is not a legitimate criteria to, I mean, it's great to have the case dismissed, but what it's not saying is that up until the maximum sentence, we can continue to hold you if you're incompetent, before we dismiss the charge. So you can't, that's not the right criteria. I didn't understand at the beginning of section 3, there's it says, if the person has been acquitted of an offense punishable by life, and the person is not deemed a person in need of treatment, then these things, what are we talking about? Are we talking about like a particular psychotic break that is unlikely to, or no evidence that it would ever recur? I don't know, I'm trying to figure it out. Because usually what happens, if you have a life in prison case and you are found insane, and as a result you're acquitted, I don't know that I've seen one where the person is not deemed. Do they mean that you are found the person deemed in treatment, or you're not? I was confused by that. You know what it's getting at?
It was explained to us, and
I think
I don't want to.
it must be like just like a temporary psychotic break or something. That's all I can think of.
Jared, can you chime in on that?
I can,
You
for the record,
articulated better than I can.
Jared Bianchi. So, first, just to get back to the misdemeanor dismissal, nothing about the draft is linked to holding a person. That would apply to misdemeanors only. It does not create a category for holding people as a result of anything. This is just a separate and distinct section that is modeled on other states where a case where a person that is pending for a period of time, the person being competent, eventually is dismissed. Nothing about holding that person, certainly nothing about aggravated assaults. With respect to that provision that General Valerio was just reading, that is one of the sections that I did offer some clarifying language more directly modeled on the federal piece, but also clarifying, because it's a person, the intention is it's a person who doesn't get hospital level care. That's the intention there, and that's the modification of that.
Thank you.
Okay.
Senator Rose.
Am I right in understanding, Joe, this might be a question for you, that language that we were just talking about is a sort of maximum, like if a case is pending and it reaches that point, it must be dismissed. There's nothing stopping it from being dismissed at any point along the way.
That is correct. That is just the longest amount of time it can pend without being addressed.
The appellate division advises me, and it was mine, that you can't have a criteria that's not mentally health based. If this is, I mean, maybe it's just out of place in the statute because it's seems like unrelated. I mean, I don't know. The cases that they refer me to that you should look at are the Jackson versus Indiana and Fucha versus Louisiana.
How do you spell that second one?
Foucha versus Louisiana, 504 US 71. It's a 1992 case. We've already talked about the burden of proof issue. And, you know, one of the things they did update me on, because I hadn't dealt with it on the federal level, 19 USC 4241, this is a federal statute regarding incompetence. The feds can hold someone securely on a finding of incompetence for 4 months, and that can only be extended if the court finds that they're about to regain competence. Recent habeas cases out of the Ninth Circuit indicated that because individuals were held in a facility for competence restoration, but they didn't get competence restoration services right away, and they defined right away as were not provided within days of detention, meant that the court treated the detention as not for treatment, but for non-treatment purposes, which violates due process. The Ninth Circuit also ruled that holding incompetent people in jail for periods more than 7 days while waiting a bed in a state hospital was also illegal, because the jails are not a suitable place for competence restoration. And that goes to the issue that Senator Bahasku brought up earlier. California has a 2-year maximum for incarcerating someone for competence restoration. California Supreme Court held that that was a hard limit, and to allow courts to extend the limit would be a 14th Amendment violation of the U.S. Constitution. The state, however, can always move for a traditional civil commitment at the 2-year mark and get themselves out of that, what was an unconstitutional process in California. The Florida Supreme Court ruled that if someone doesn't regain competence after 5 years, they must be released or civilly committed. The bottom line is that we need a forensic facility. We just need to do it right. And the way this seems to be written is it's all about public safety and not about what forensic facilities are supposed to be about, which is treatment of people with mental illness. This is something the nation has struggled with and people struggle with, because you see the results of what occur when mentally ill people do things that are, awful. But once you get out of the kind of criminal realm, the whole paradigm of what you need to do to treat them and deal with them is different. Those are not things that my office will be dealing with. We will probably necessarily end up with sort of the aftermath if cases end up coming back, into the criminal arena. But it is, I don't know, I think there needs to be some work done on this.
Yeah, we are getting some suggested edits, and there are also suggested edits from AHS and the others from the state's attorneys. So we'll be getting a second version of this draft next week, which may or may not address some of these issues, but
yeah, I mean, I have significant concerns about the Commissioner of Corrections being in charge of a treatment facility for mentally ill people.
Committee, any questions or comments?
I just want to make sure I touched everything. But gonna get most of it.
Thank you.
Just, you know, I don't know that I wanna go through it and rewrite the whole thing, to be honest. It's not my, you know, unfortunately, it puts me in a position of kind of being on the outside saying, this stinks, this stinks, this stinks. But, you know, there probably could be things that you could suggest, but it, you know, I don't think that the Department of Mental Health would appreciate my suggestions on how they should run their shop.
Well, thank you. Committee, we're still ahead, and so I want to give Jared an option, if you wanted to respond to any of this, if you have 10 minutes or so.
Sure, that'd be fine.
We can wrap up here.
I'm sorry I can't stick around. I've got too much.
No worries.
Matt, you said it would be legal aid that would step in to represent folks in this
A
system?
couple of years ago, when you guys passed S3, we used to do the hospitalization and orders of non-hospitalization hearings to develop the initial orders, and then legal aid came in. And legal aid in our office were at odds to some degree about, you know, we didn't like the way they did it, they didn't like the way we did it. They ended up taking over that portion so they could litigate their own orders. And so, you know, after the finding of incompetence or insanity, they come in.
Awesome, thanks. It might make sense to hear from them and if they have a way to navigate it
They're, I think
constitutionally.
they're probably the most important.
Vermont Legal Aid?
Oh, yeah.
Yeah, we did hear from them a week or two ago, but we'll bring them back.
I think,
Sorry, could you just reintroduce yourself?
my apologies, Jared Bianchi, Deputy State's Attorney. General Valerio mentioned a piece having to do with company restoration services maintained quote until the person receives a verdict. Of course, the intention would not be to maintain services for the person. They should be appropriate services that are necessary and well sought, well received. I think an easy way to deal with that is simply change the shall to may.
Where, which page and line are you on?
This is page 3 in as currently before the committee, page 3, line 5, it's subsection E. This competency restoration services shall. I think a may would address his concern and would not alter the nature of what we're trying to accomplish there. We're not trying to impose services that aren't effective or appropriate. I think that there was some confusion about the way that the misdemeanor dismissal piece fits into this. That is not intended to bring misdemeanor cases within the ambit. The reason that it's there in the statute is because it would be a new section of the law. And so if you look at the way that the bill is structured, these are new sections, and then there's a new section A that creates a special version of the competency for these life offenses. And then another new section later that talks about dismissing misdemeanors. So it's structured around the flow of the chapter as it currently stands and inserting new statutes within there.
As it currently stands, those misdemeanors could pend forever,
Yes.
right? So this is a hard line and like, no, they may not pend forever.
That's right.
Okay,
Yes, that is correct.
great, thanks.
And in terms of the burden question, I think we already went over it in our testimony, but it is structured on the federal model, and it really is structured around a circumstance where a person's already been adjudicated. So I'll leave that testimony where it was. I think maybe because I know that you have limited time, was there anything in particular? There was one other piece I wanted to touch on when he was talking about subsection C in, I didn't catch, I think it was section A. Nothing prohibits addressing the cases through a Rule 48 motion to dismiss. So while there are statutory provisions in here that go to certain discharge criteria, one of the ones that the general noted really had to do with keeping a person there until a case was dismissed. Well, Rule 48 allows dismissal of a case in the interest of justice, and there is a judicial test for that. But that's the mechanism that already exists. It doesn't need to be codified here to address a circumstance where a person, it's no longer clinically appropriate, or the person's unrestorable, et cetera. That's already a part of the criminal rules that could be found there.
Thank you. Committee, any other follow-up questions for Jared? Yeah, just wanted to give you a chance to respond to,
Thank you.
Matt Valerio, so, okay, thank you.
Thank you, Senator.
Doesn't seem too complicated.
Simple vote.
All right.